Getting fired is hard enough, but when you know the reason was unfair or even illegal, it's devastating. Many workers ask, "What should I do if I've been wrongfully terminated?" The truth is, while the US follows at-will employment, there are important exceptions. You cannot legally be fired for reasons like discrimination, retaliation, exercising your rights under laws like the FMLA, or refusing to do something illegal. So, what happens if you think your firing crossed the line? You don't have to just accept it. There are clear steps you can take to protect yourself, gather evidence, and even fight back. In this video, we'll walk through exactly what to do if you've been wrongfully terminated, how to spot the red flags, document your case, file complaints, and pursue legal remedies. Part 1. Recognizing the signs of wrongful termination. The first step after losing your job is to determine whether your firing was simply part of at-will employment or whether it qualifies as wrongful termination. Not every unfair firing is illegal, but there are red flags that suggest your rights may have been violated. Start with discrimination, where you let go because of your race, gender, age, disability, religion, or another protected characteristic. Under laws like Title VII of the Civil Rights Act, the Americans with Disabilities Act, ADA, and the Age Discrimination in Employment Act, ADEA, employers cannot fire you based on those factors. Next, consider retaliation. If you recently complained about unpaid wages, reported harassment, filed for workers' compensation, requested family or medical leave, or raised safety concerns, and then lost your job, retaliation may be the real cause. Federal laws like the FLSA, OSHA, and FMLA make retaliation illegal. Timing is another clue. If the firing happened soon after you engaged in a protected activity, like filing a complaint or taking medical leave, that close connection can be powerful evidence. Also look at your employment status. If you had a contract or worked in a unionized environment, the employer may have been required to show just cause and follow specific procedures. If they skipped those steps, it may be a breach of contract or labor law violation. Finally, think about whether you were asked to do something unlawful. If you refused to falsify documents, ignore safety rules, or break the law, and were terminated as a result, that falls under the public policy exception to at-will employment. The bottom line is this: wrongful termination happens when the firing violates a law, a contract, or public policy, not just when it feels unfair. Recognizing these signs early will help you decide on your next steps and strengthen your claim if you choose to take action. Part 2. Collecting evidence and building your case. Once you suspect that your firing may have been wrongful, the most important thing you can do is gather evidence immediately. Cases of wrongful termination often come down to documentation, what you can prove versus what your employer claims. Start with employment records. Save copies of your offer letter, employment contract, employee handbook, and any written policies. These documents often spell out whether your job was at will, what rules applied, and what procedures your employer promised to follow. Next, gather your performance history. If you had good performance reviews, awards, or positive emails from supervisors, keep them. They can be powerful evidence if your employer tries to argue that you were fired for poor performance. Collect communications. Save emails, text messages, or notes from conversations with supervisors or HR. If your boss made discriminatory remarks, pressured you to skip breaks, or threatened you after you filed a complaint, that evidence is critical. Even casual comments can help show bias or retaliation. Don't forget witnesses. If coworkers saw or heard unfair treatment, ask them if they'd be willing to provide statements. Courts and agencies often give weight to corroborating testimony. Also, keep track of the timeline. Write down dates of important events, like when you reported harassment, when you requested medical leave, or when you were fired. If termination closely followed a protected activity, That timing may support your case. Another important step is preserving pay stubs and schedules. In wage-related cases, showing that you worked hours off the clock or were denied overtime before being fired can strengthen your claim. Finally, avoid deleting anything, even if it feels minor. A single email or text could make a huge difference in proving your case. And, if your employer controls digital accounts, back up your records before you lose access. The reality is, employers often try to justify wrongful terminations with vague or fabricated reasons. Having a clear paper trail puts the power back in your hands. It shifts the case from your word against theirs to a documented story that shows what really happened. By collecting and organizing evidence right away, you give yourself the strongest possible foundation for the next step, filing a complaint or seeking legal help. Part 3. Filing complaints with the right agencies. Once you've gathered evidence, the next step is knowing where to file a complaint. Wrongful termination cases often begin with government agencies that enforce workplace laws. Which one you go to depends on the type of violation. If you believe you were fired due to discrimination based on race, sex, religion, age, disability, or another protected category, you should file a charge with the Equal Employment Opportunity Commission, EEOC. This is the federal agency responsible for enforcing laws like Title VII, the ADA, and the ADEA. In many states, there are also local human rights agencies that work with the EECC. If you think your firing was tied to wage complaints or overtime issues, the U.S. Department of Labor's Wage and Hour Division, D, may be the right place. They investigate cases under the Fair Labor Standards Act, FLSA, and can order back pay and damages. For safety-related retaliation, such as being fired after reporting unsafe conditions, the Occupational Safety and Health Administration, OSHA, is the enforcement body. They can investigate and even order reinstatement. If your firing was connected to taking medical or family leave, you can contact the Department of Labor as well, since they enforce the Family and Medical Leave Act, FMLA. For issues involving workers' compensation, each state has its own agency or board that handles retaliation claims. Filing with your state labor department is usually the path forward. Timing is critical. EEOC complaints generally must be filed within 180 days of the termination, though some states extend it to 300. OSHA retaliation complaints often have even shorter deadlines, sometimes as little as 30 days. Missing these deadlines can mean losing your chance to bring a claim. Filing a complaint doesn't always mean going straight to court. In many cases, agencies will first try to resolve the issue through investigation, conciliation, or mediation. If that doesn't work, they may give you a right to sue letter, allowing you to take your case to federal or state court. The process may feel intimidating, but remember, these agencies exist to protect workers. Filing a complaint isn't just about your case. It also helps hold employers accountable and prevent them from mistreating others. Part 4. When to hire a lawyer and what remedies are available. While government agencies can investigate wrongful termination, sometimes the best way to protect your rights is to hire an employment lawyer. A lawyer can help you navigate complex laws, meet strict deadlines, and negotiate from a position of strength. So, when should you consider legal help? If your case involves clear discrimination, retaliation, or breach of contract, or if your employer is a large company with deep resources, having a lawyer is invaluable. Attorneys understand how to gather additional evidence, depose witnesses, and prove that the employer's stated reason for firing was just a pretext. Many employment lawyers work on a contingency basis, meaning you don't pay upfront. They only collect a fee if you win your case or reach a settlement. This makes pursuing justice accessible, even if you've just lost your paycheck. What remedies are possible in a wrongful termination case? Back pay. This is compensation for wages and benefits you lost from the date of termination until resolution. Front pay. If getting your old job back isn't practical, courts may award pay you would have earned moving forward. Reinstatement. Sometimes the court or agency can order your employer to give you your job back. Compensatory damages. These cover emotional distress, reputational harm, or other personal losses. Punitive damages. In cases of extreme misconduct, courts may award extra damages to punish the employer and deter future violations. Attorney's fees. Many employment laws allow workers who win to have their legal fees paid by the employer. A lawyer can also help determine if you have multiple claims. For example, if you were fired after filing both an overtime complaint and a harassment report, you may have overlapping protections under FLSA and Title VII. Employers often settle wrongful termination claims before trial, especially if the evidence is strong. Settlements can include not just money, but also positive job references or agreements not to contest unemployment benefits. In short, hiring a lawyer gives you leverage. They know the system, the deadlines, and the strategies to hold employers accountable. And they can help you recover far more than you might achieve on your own. Part 5. Practical tips, real-life examples, and encouragement. If you believe you've been wrongfully terminated, remember that you're not powerless. There are concrete steps you can take to protect yourself, and many workers before you have successfully fought back. Here are a few practical tips. Stay calm and professional. Even if you're angry, avoid burning bridges or saying things that could be used against you later. Ask for documentation. Request a termination letter or written explanation. Even if they refuse, the request itself shows you were proactive. Apply for unemployment benefits. In many cases, you're eligible even if you were fired, unless it was for serious misconduct. Network and job search early. While your case moves forward, start looking for new opportunities. Courts may reduce damages if you don't make a good faith effort to find work. Real-world cases show how workers can win. For example, a group of call center employees in Texas sued after being fired right after filing an overtime complaint. The court awarded them not only back pay but also liquidated damages, double the amount owed. In another case, a hospital nurse who was terminated while on medical leave won reinstatement and compensation through the FMLA. These victories send a clear message. Employers who think they can ignore the law often pay heavily when workers stand up. The most important takeaway is this: don't assume that being fired is the end of the story. If your termination was discriminatory, retaliatory, or violated a contract or public policy, you may have strong rights. With documentation, persistence, and the right support, you can turn a wrongful firing into accountability and sometimes even a fresh start. So, what should you do if you're wrongfully terminated? The answer is simple but powerful. Act quickly, document everything, and use the protections the law gives you. At-will employment gives bosses broad discretion, but discrimination, retaliation, breach of contract, and public policy violations are never legal reasons to fire someone. Start by recognizing the signs, saving evidence, and filing complaints with the EECC, the Department of Labor, or your state agency. If your case is strong, consider working with an employment lawyer to maximize your chances of back pay, damages, or even reinstatement. The most important thing to remember is this: you're not alone. Many workers have faced wrongful termination and won. By standing up for your rights, you not only protect yourself, you also help create fairer workplaces for everyone. If this video helped you, hit like, share it with a coworker, and subscribe for more plain English guides to workplace law.